So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about news out of Canada. The Labor Relations Board in Ontario found that an employer cannot use the results of a post-incident drug test to suspend them. And it's a pretty curious case here. The employee was reversing a vehicle into the hitch of a trailer, damaging the door of the vehicle. There were a lot of different causes for the accident. The employee was facing towards the sun. These are all kind of in my money, excuses. But the trailer was in a blind spot. You should be looking, and the other employees did not act as a spotter as was required. Which, of course, if that's the case, the employee should not have been using it unless they had a spotter, which is just again one of those frustrating things as employers at times. There weren't any resulting injuries and only minor damage. Okay, that's important. That's very important. As a result of the accident, the employee had to provide a urine sample, and they tested positive. He had used marijuana while off duty the evening before. As a result, employee was suspended and terminated from his employment, even though marijuana didn't actually contribute to the accident itself. There's no evidence of the consumption was a contributing factor, and frankly, probably wasn't, right? The union for the employee argued that the employee was subjected to unreasonable drug testing and was wrongfully terminated. And the vice chairman agreed that they can't do a result because they were improperly obtained. And this is what I want to talk about in the context of United States labor law and everything that goes with it. There was an OSHA rule that went into place in like 2016, 2017 that required employers to establish, quote, reasonable procedures, end quote, for employees to promptly and accurately report work-related injuries and illness. What OSHA was concerned with at the time was the idea that people would not report injuries because they were concerned about a drug test. And so OSHA required that the drug test be reasonably related to the injury itself. And for example, you could not simply be stung by a bee and as a result, test positive for drugs, right? The bee is not related to any drug use. And OSHA came in favor of that in 2016. OSHA stated that although drug testing of employees may be a reasonable workplace policy in some situations, it is often perceived as an invasion of privacy. So if an injury or illness is very unlikely to have been caused by employee drug use, or if the method of drug testing does not identify impairment, but only use it sometime in the recent past, requiring the employee to be drug tested may inappropriately deter reporting. And that's what OSHA was concerned about when this was put into place. Personally, I think that this ban on, or this reinterpretation of post-injury drug testing, specifically surrounding electronic data reporting requirements, was a good one. It was eventually removed, and I can't find the specific date that this rule on OSHA was removed, or this rule on data reporting was removed from the logs. I imagine it was sometime during the Trump administration, but I can't find it. This ultimately was removed, but I do find that employers should be pretty careful about when they drug test people. The problem you ultimately have is uniformity and people claiming that you're discriminating because you're making this choice to drug test versus that choice. And that's why, frankly, most employers went to a blanket choice, right? Blanket drug test, regardless of what happened. And I always tell the story. It's kind of a funny story. It's one I heard a long time ago. I don't know if it's don't wasn't present for it, but there was a person working at a chicken plant who was using knives. They had a person behind him. The person using the knives accidentally stabbed the person behind him. That person was hurt, and because they were involved in an incident, they were then drug tested, and then after their stabbing, they were then fired for testing positive for drugs. And that's what can happen in a post-accident drug test, and that's what it looks like. It looks like Canada is going against here. Uh, the chairman reviewed the case law in Canada, saying, well, employers must balance the interest in a safe workspace against privacy interests. You have to make sure that the context and circumstances must reasonably warrant testing, that the presence or absence of a legitimate explanation for the accident is relevant, that the conduct of the employer should be taken into account, and trivial events do not justify testing. And as a result, the board, the Labor Relations Board of Ontario, found that the employer could not use the results of the post-incident drug test. Let me know what you think about this in the comments down below. Is this reasonable from Canada? What do you like about it? What do you not? Like, share, and subscribe, and we'll see you on the next video. Bye, guys.